My name is Mackenzie Wilson, and I will be giving my presentation today on forum shopping. Forum shopping is a practice used by a prosecutor in a legal case where he or she will refile a case until it lands in the hands or grounds of a jurisdiction that will likely give the most favorable ruling to their argument. So that is the argument of the prosecutor or the attorney that filed the case. Oftentimes, an attorney may try to relay their case to previous cases that the judge or jurisdiction has tried in order to increase the likelihood of the case being heard. Some major opposing viewpoints of this would be that it creates an uneven distribution of cases between jurisdictions. And an example of a case that I found where this happened would be the TC Heartland versus Kraft Foods Group Brands case. And in this case, TC Heartland versus Kraft attempted to sue TC Heartland for patent litigation, which is basically the manufacturing or distributing of someone else's creation without their permission. And they tried to do this through the District of Delaware. But where the problem started was that TC Heartland denied and requested the case to be transferred to the Southern District of Indiana because this is where they were based. They had no business, no workers, and no relation with the District of Delaware. So this went to the Supreme Court, where they ordered the case to be transferred to the Southern District of Indiana because of Section 1400B. It states that 1, the judicial district where the defendant resides, or 2, wherever the defendant has committed acts of infringement and has a regular established place of business, is where the case should be tried. This created a huge shift in where people chose to get their patent litigation cases heard in district courts. Delaware used to lead with these cases, and they dropped a significant percent, and the Southern District of Indiana increased greatly in their percentage of cases heard having to do with these patent litigations. Another big opposing viewpoint is, besides it being viewed as unethical, it creates an unfair and unpredictable atmosphere for the defense. And the case that I use for this would be the European Union and the European Courts of Justice on cross-border insolvency cases. With this case, what they decided was, in order to frustrate forum shopping, the EU and the ECJ utilized a COMI, which stands for the Center of Main Interest, to be the determinant in which international jurisdiction would hear cross-border insolvency cases. The way they did this is they established 4 legal tools. The first is that the company would send the EU or the ECJ their COMI to determine which court would receive their case. The second one is that the EU or the ECJ would then decide when to conform the COMI with the council regulation to choose the jurisdiction. And the third one would be to implement, I'm not sure how to pronounce this, Perpetuitio Fori, and that is the international jurisdiction of courts of a member state, once established, continues to exist, in which can frustrate debtors' attempts to transfer COMI to another member state. And number 4 is the inability to transfer the COMI to another member state since proceedings have begun. So through these 4 legal actions, they basically make it a very difficult process to try to forum shop and make it where you have to go through legal bodies and lots of steps to do so. The supportive viewpoints of forum shopping is that it is looked at as simply working towards the best interest of a client, which is an attorney's duty in a case. Many argue that if you don't utilize this action, you're necessarily not doing your job, or you're not fulfilling your duty. And then others argue that it is necessary to get an adequate review of the case being filed. They feel as though no one's actually going to look at their case in detail and actually review it. They feel as though when they forum shop, they'll get the best review on their case. And the example I used for this was the forum shopping for human rights. With these cases, individuals create petitions to address the basic human rights that they feel have been violated. They offered a reform of forum shopping, including simultaneous and successive forum shopping. And what they did, what their main focus was to reform successive forum shopping, in which they broke it down into 3 disputes and they ordered it into which they should be considered. The first one, or the first dispute, would be new claims that were added to the new petition that were not included in the original petition. The second dispute would be that claims that were present at the time of the original hearing, but they were not included in the petition. And the third dispute would be all claims were included, but the court rejected or ruled against them. And how they should be considered is basically in order. Number 1 should be top priority. Number 2 should be somewhat considered, but less. And then number 3 should be very rarely considered, if at all. Then you have the in-between viewpoints. So this is where people necessarily don't agree with it, but they also don't disagree. So they feel as though it is something that should be utilized only for specific cases and not overused. And the example I used on this would be Europe on crashing corporations. And this is something that has taken place in both Europe and the US, so I almost did somewhat of like a comparative analysis of this. So they're struggling companies that are brought to responsibility to pay off their debts, and they seek out courts that favor or support these kinds of problems. So this is the issue that both Europe and the US were having, where these corporations that were crippling under their debt, they couldn't pay it off, and they were seeking out these forums that they knew would favor their side of the case, that they favored debtors, so they would try to help them and bring their business back together. And in Europe, they actually supported some of these cases and saw it as a way to rescue corporations, while in the US, they viewed it as somewhat of a corruption and they did not support these. So my conclusion is that while there are 3 different viewpoints, the most common one is that forum shopping is an unethical abuse of power that should be abolished. I do agree it is unethical, but I believe that it's not something that can just be done away with since it is used so much, and that instead we should frustrate the process and limit the availability of it to attorneys. So by doing that, my plan would be to create an application process where an attorney can only apply to 2 courts of their choosing, but they have to apply and they have to get it approved by the general attorney and by the actual jurisdictions that would be trying the cases. And there would be a limit set on this, so they could only apply 1 time per month and 3 times per year. And that is all. Thank you.